appeal in the matter of Banca Intesa Sanpaolo SPA and another, Comune di Venezia.
Yes. Good morning, my lords and lady. My lord, may I just clarify, begin by just clarifying, seeking to clarify, I hope, one matter that arose yesterday. For your lordship's reference, in the transcript from yesterday, page 78.
Sorry, page?
78.
That's yesterday. That's yesterday. $78.
Yes.
Right. Okay.
And
I'm not sure that my Lady Justice Falk has been receiving the transcripts. I have.
I can get them via the.
for this purpose, my lady, I hope it won't.
Okay.
It won't matter.
Yeah.
All I want to do is just clarify, because I may not have explained myself very well. Your lordships may remember this was I was on the point that still on the point that the correct comparison in this case, for the purposes of deciding whether or not a swap is speculative, is between the underlying transaction and the swap, and not between the closed-out swap and the new swap.
Okay.
And at the top of page 78, what I was seeking to do, and obviously failed to do, was to make the point that our submission is that was the position of the correct position. That is, the correct comparison is between the underlying and the new swap, for the purposes of deciding whether or not a swap is speculative.
Yeah.
Was the position of both the banks and us at the trial. And I can see from the transcript that it may be. I'm not wishing to ascribe.
I think I don't. This is the problem with having something is on paper and something that's electronic. Because page 78 of the paper transcript is not anything to do with this at all. I don't think.
Well, my lord, let me just.
It begins at the top of the page, speculative if it is rolled over into a new swap.
That's probably yes. That's different from my page 78.
It's not. It is my copy, same as yours, my lord. The hard copy.
Same as mine, is it? Yes. This is an example of what is the modern version of Sedley's law of procedure, which is that one of my masters has developed a modern version of it, which is actually the most entertaining. One of which is that under no circumstances should the page numbers in the paper bundles correspond with the page numbers in the electronic.
Or indeed between paper copies sometimes.
Precisely. Anyway, what page do you think it is?
I'm being told it might be page 82 in
Right,
the
okay,
version. I don't know if we can try that. At the very top, it begins at paragraph 8.
Okay, well, just tell us what the point is.
Well, I don't want to take up time with this, my lord, but I did want to clarify. So the point I was seeking to make was that the correct comparison is the one I've been talking about. The underlying is the new swap. And here I was making the point that that was the position of the banks at the trial below and of us. But my impression reading the transcript is that your lordship may have had the impression that the point was different, and that the point I was trying to make was that the rolling of the negative MTM into the new swap wasn't something that was to be taken account of in relation to speculation, and that was not at all my point. In fact, quite the opposite. That's very much the point that we make. It's very much the point that, as your lordship picked up,
Well, I don't think
The
I was
judge.
under that impression, so I think points is
Well, maybe
it's
I've
out
gone
of
for
an
the wrong
abundance of
target.
caution, but we quite understand that's the what, because that's effectively what the judge has decided. And the
Yes.
judge in paragraphs 229 and 230 has decided that this swap is speculative precisely because it's priced on the basis that it's buying out the previous swap.
Yes. My lord, yes.
So and that was your case, and it still is your case.
Yes.
I don't think we've misunderstood anything.
My
So
lord,
should we move on?
yes. So I'm now turning to ground 4. Which is the retrospective point. And I'll deal with permission first and then with the ground. In relation to the principles, it's the Times Travel case, and your lordships have already seen that.
Yeah.
And the question is, would the court allow a new point to be heard on appeal? It will not do so if it would necessitate new evidence. The principle here relied on, sought to be relied on, in relation to retrospectivity is, on any view, a novel one. But the banks themselves say there's no clear authority at the skeleton at paragraph 111 sub 1. The principle, so far as formulated by the bank, is at paragraph 107 of their skeleton.
(107).
107 in the middle, accordingly under English law, a not reasonably foreseeable judicial decision of a foreign court after the date of contracting, which purports to have retrospective effect, will not apply for the purposes of ascertaining a party's capacity to contract or any other aspect of the validity of the relevant transaction. The elements of that principle include these: not reasonably foreseeable, the retrospective effect of the decision, and within that, the law as at the date before the application of the judicial decision in question. Our submission, as your lordships know, is that this, the decision of this issue would involve necessarily new evidence. Now, firstly, in relation to the question of reasonably foreseeable, this is a novel principle, but and so one hasn't got any guidance on it. But immediately the question arises: by whom? Reasonably foreseeable by whom? Is it meant to be reasonably foreseeable by somebody who is relying on the law not changing? Because if that's right, then it's the banks.
Well, this is very dangerous territory for you on ground 5, isn't it, Mr. Cox? I mean, your position at the trial was that this was just not reasonably foreseeable, which I took it to mean by anybody.
Yes.
So trying to pass it between the two parties runs into some fairly dangerous territory, as I just said, in relation to limitation.
Well, my lord,
I mean, this point only, your objection to this point on this basis
yes.
only really runs if you can satisfy us that for some reason some new evidence would be required.
Exactly. Yeah. So that's what I'm.
That's the issue. What new evidence would be required and why?
Yes.
I mean, the point may be a good point or a bad point. At the moment, we're at the threshold issue of permission.
Yes. My lord, yes. The question of what evidence is required depends obviously on what the principle calls for, and it was that I'm just raising a question about, because in order to know what evidence is required about reasonable foresight, one needs to know, well, presumably objectively, who is supposed to have reasonable foresight of that?
What new evidence would you want to call? Don't worry about the banks, because if they need new evidence, they haven't got it, so that's going to be tough for us. But what would you want to call from your side?
Well, we would want to call evidence about the law as it stood in relation to 2007, and we would certainly wish to call evidence about the effect of Cattolica within the Italian judicial system.
Effect of Cattolica.
In the Italian legal system.
Can you explain what that means?
Well, it's a system where, as has been said already a couple of times, the decisions of the courts are non-binding. But this principle appears to be depending on the retrospective effect of the judicial decision. Now, I don't know, and we haven't gone into this. Here in the UK, one could understand a point that a new decision at the House of Lords in Hazel or any other decision declaring the law as it was at 2007 would have a binding effect on every court in the land. The position is by no means necessarily the same in Italy. And that seems to us to be highly relevant to...
But doesn't the point arise in this way? That the judge, the task that the judge was engaged in was in determining what would the highest court in Italy, namely the Supreme Court, decide in this context.
Yes.
And he has said, well, look at Cattolica, which is a Supreme Court decision, and for the reasons he gives in his judgment, your clients succeed on what's now grounds 1 and 2 and 3, albeit that 3 involves English law as well. The argument that's now being run by the banks is an argument that says, well, taking all that as read, as it were, as read, the fact is, if one's looking at capacity of an Italian body as at 2007, it's not appropriate to look at the decision of the Supreme Court in 2020 and to give it retrospective effect.
Yes.
So how the Italian judicial system regards Cattolica and the fact that they don't have a doctrine of binding precedent, etc., in one sense, there is Italian law evidence about the fact it isn't binding, there isn't a sort of binding precedent. But how it's been sort of dealt with in the Italian judicial system is not really relevant, is it, to the issue that raised by Ground 4?
Well, it's part of the formulation of the principle, right? Which is where we start. It has to be not reasonably foreseeable, and it has to purport to have retrospective effect.
Well, if it doesn't have retrospective effect, then the banks established that in 2007 Venice had capacity by reference to other materials.
Well, My lord, they may, but that's not this principle.
Sorry. By the judge's decision, if grounds 1 to 3 are not upheld, isn't the effect of that Catholica is regarded as having effect in 2007? Doesn't it just follow?
Well, the English court judgment would obviously have its effect. The English court.
The English court is determining what the highest foreign court would decide. Effectively, as at 2007.
Yes. If I may say so, they're absolutely right. And in a way, these questions arise out of this principle. You know, one is trying to understand how you apply it in our context. Right. And it may be because it really, so many of the cases that are here referred to, I don't want to take too much time on this, but we'll come on to this. They're talking about legislation, where it's absolutely clear what happens. But there's a complete divide, in my submission, between legislation on one side and court decisions on the other. And they raise very different considerations. And this is one of them.
Well, you may be right about that, and if so, that's an answer to this point. But that doesn't really go to the question whether further evidence is required.
No, that doesn't actually require evidence, that requires submissions.
Well, it does, and I wasn't on there making the point that requires evidence, but the points I'm making, and these are my submissions, are that we would want to call evidence about the retrospective effect or not of decisions at the highest court in Italy. And that was not considered below. As such, of course, there was some reference to the role of Catholica, but this principle hasn't been put, and that issue wasn't raised. Now, the other aspect of this, the law as at 2007. What the judge? So again, that wasn't something that the judge decided. What he decided was that the law as declared in Catholica, which declared the law, appeared at any rate to us to declare what the law was in 2007 and always had been. But if you're now dealing with a claim that Catholica is retrospective in effect, then you do need to go back and look at what the law is said to have been as at the time of the entry into the contract. And again, that isn't something that has been decided. Now, the banks say, well, the judge has decided all these matters, but in my submission, that's not the case. And that's the essence of it. It probably doesn't bear much repetition. If I'm right, then really the only appropriate course on this point would be, if we got this far, and this was live, factual decisions factual matters to be resolved by the trial judge in order that the application of the principle could be applied. My Lord, stand if I may, I'll just move on to the merits of the appeal in relation to this point, assuming that permission is given to argue it, to make it. My Lords, the general principles in relation to the temporal effect of the applicable law are dealt with in Dicey, And if I could ask you please to turn that up. It's in it's in the final bundle of authorities. Tab 137.
127.
137, my lord.
Really?
And
We've got 137.
It's, the soft
very-
copies were updated, so that's.
Haven't got it in an electronic form. It's been stuck in the back of a bundle. It's got about 600 pages in it.
I'm sorry, my lord, we'll
Which is
make
more
sure that
than,
you
uh,
get the electronic.
This is why we haven't had to open these paper bundles very often.
I'm afraid I've been working off the electronic bundles. I haven't brought the paper bundles with me because there are 15 of them, possibly more. So I don't have this material.
I'll just take instructions. My lords, I'm sorry about this, but I understand that there has been supplied an additional
Well,
separate.
never mind what's been supplied or not supplied. Does somebody have a paper copy of tab 137 in court, which will be given to my Lord Lord Justice Mayor? Okay, we've got one. Good luck with opening it.
I'm grateful, my lords. Sorry about it. Paragraph 2067, so page 6603.
2067.
2 dash.
My lord, I'm sorry to interrupt. I think no one on our side has this either. But I'm happy to just follow.
No, I'm sorry. We'll just make sure that we have it. I'll get one as soon as I can.
Right, why don't you just read out
That's
the
fine.
text of what you want to rely on? And I'm sure that those behind Mr. Laney can. Somebody can
my lord,
to look
yes.
for it.
Yes, so 2067 in English law, changes in the conflict rule of the form, this is what it's talking about, may occur in 3 ways. And then it sets out the ways, including a judicial decision may reverse an earlier judicial rule or declare a new one. And then 2-076, changes in the lex causae, just the top part of that, my lords, if we do have it at all. Sorry.
Changes in the lex causae present much more important and difficult terms. Time.
Yes, it's the overwhelming weight of opinion among writers. The form should apply the lex causae in its entirety, including its transitional rules. It's probably the prevailing practice of the English courts. Although there's one case, which is the Lynch case you referred to, which is often cited for the contrary proposition.
Yeah.
And then at 2-077, Dicey goes on to emphasise the problem is always basically the same, namely should the form apply or disregard subsequent changes in the lex causae. But it again considers the problem under several heads. And you have succession to immovables, which is the Nelson and Bridport case you were referring to. Lord Langdale took for granted he had to apply the law of Sicily as it existed from time to time. Succession to movables, opposite result was reached in Lynch, and that was a case that you were shown. And then there's an extended discussion of that. And then other areas, torts, and then your lordships will see 2084, discharge of contracts. And this is obviously significant in our case. In common law, the discharge of contracts affected the substance of the obligation and therefore normally depended on the law governing the contract. Position the same under Rome 1. Numerous common law decisions clearly established the content of the rules of the governing law was that which existed from time to time, and that therefore legislation enacted in the country whose law governed the contract after the date of the contract may have the effect of discharging or modifying the contractual obligations. And then a striking example, and then it refers to the international trustee and bondholders case. And then over the page,
That was a case in which the contract was governed by New York law.
yes,
So it's the result is perhaps not surprising.
not so helpful, yes. And then 2085, Adams is referred to, which your lordships will remember.
Yeah.
One of those cases where you had varying reasons given. The House was not unanimous in its reasons for reaching the conclusion. But the main reason seems to have been that since the law applicable to the contract was English, no Greek law could discharge one party's obligations thereunder. And then I don't need to refer to any more in that extract. Except possibly one thing, actually, 2-090, under public policy, the prevailing practice of English courts thus seems to be to apply the lex causa as it exists from time to time and to give effect to retrospective changes therein. And then it goes on to say the consequences of giving effect to the retrospective changes, sometimes so extraordinary, public policy must occasionally impose qualifications and exceptions. It's almost a complete lack of English authority on the question. And then there are references including to the Starkowski case, which the lordships were referred to, the marriage case. So that's what Dicey says about the scope of the applicable law and the question of the retrospective effect of the applicable law in contract. Now, in relation to the cases that Milena Trent has referred you to, the Lynch case and the Adams case, they were not concerned with judicial decisions. What we see are cases that that turn on legislative interference or steps. And secondly, they do not have any kind of qualification in them, or express support for any kind of qualification based on reasonable foresight or reasonable foreseeability. And thirdly, they do not involve capacity to enter a contract. So that you really are being faced with a novel proposition for a principle based upon cases which are, in key respects,
do involve, well, Adams at least does involve the issue of discharge of a contract.
Yes.
rendering a contract void by virtue of events that have occurred after the contract's made. In that instance, the passage of legislation
Yes.
in Greece.
Yes.
So you're absolutely right. It's not about capacity, but surely the analogy is a fairly obvious one.
Well, the analogy is proposed.
I mean, it depends upon an argument, doesn't it? That as at the date the contract was entered into, Venice had capacity to enter the contract. The effect of Cattolica as a matter of Italian law is that Venice is deemed never to have had capacity to enter the contract. And the argument that's run is that decision of the Italian courts should not have a retrospective effect any more than a piece of Italian legislation to the same effect would.
Would, yes.
Because the contract which it affects is a
Yes.
contract that's done by English law. And that's the argument.
That's the argument. But what I'm submitting is that the material that's been shown to you, which I've so far considered, the common law cases, they don't deal with judicial decisions. They deal with legislative. They don't support, refer to, contemplate reasonable foresight. And they don't deal with entering a contract. So that to the extent they're sought to be relied upon by analogy to support this novel principle, they are, well, they have those differences. And in my submission, they're significant differences. One is faced with a proposed principle, which actually is quite far removed from the cases sought to be relied upon.
Yeah.
Now, the learned friend also seeks in her skeleton to rely upon analogies from other areas. And your lordships will see that in the skeleton for the banks at paragraph 108. European Court of Human Rights, Court of Justice of the European Union, and Supreme Court of the USA. And Millenfriend hasn't taken you to those, but those cases referred to in relation to those areas. We make a couple of points about this. The first is that these decisions are within the context of particular sets of rules. Obviously, the Convention on Human Rights and the law of the United States. And not only that, but also many of these are criminal decisions. There are decisions about criminal law. And of course, even within those systems, retrospective criminal offences are treated very differently from retrospective acts in a civil context, for obvious reasons. So one has to be very wary about any analogies from a different system, and particularly based on criminal cases. That's all I want to say about that. The next area is reliance on A1P1, Article 1, Protocol 1. And this is dealt with in Millenfriend Skeleton at 109 and 110. And in relation to this, what is, if one looks at the jurisprudence in relation to A1P1 rights, it is evident that the European Court of Human Rights has recognised that there's nothing in principle wrong with retrospective, even legislation, within certain parameters, so that one can see that those cases, which I'll just show you now, don't support the idea that retrospective changes are in and of themselves objectionable. The first case is Zelensky, and it's in tab 104 of your Lordship's bundles, I hope, I believe. 104. Decision of the European Court of Human Rights. It's perhaps the leading case in this area. Does your Lordship have that? 104, page 5580 in paper, 5586, I think, electronically. And your Lordship's has at paragraph 57. The court reaffirms that while in principle the legislature is not precluded in civil matters, and that's because criminal matters, there are different rules, from adopting new retrospective provisions to regulate rights under existing laws. The principle of the rule of law and the notion of fair trial enshrined in Article 6 preclude any interference by the legislature other than on compelling grounds of general interest with the administration of justice designed to influence the judicial determination of a dispute. So that I'll just show you the other case and then draw what we can from that. But tab 103, preceding tab, National and Provincial Building Society. Page 5557 in the paper. 5563 electronically. And your Lordships will see the European Court at 112, just above the middle. As noted above, the Court's especially mindful of the dangers inherent in the use of retrospective legislation, which has the effect of influencing the judicial determination of a dispute to which the state is a party, including where the effect is to make pending litigation unwinnable. Respect for the rule of law and the notion of a fair trial require that any reasons adduced to justify such measures be treated with the greatest possible degree of circumspection. However, Article 6.1 cannot be interpreted to prevent any interference by the authorities with pending legal proceedings to which they are a party. So, what we see from those two cases in the European Court in relation to this area, A1P1, is that in relation to legislative interference with judicial decisions, it is recognised that there's nothing inherently offensive, objectionable about retrospective legislation, but it has to be very carefully undertaken and justified.
So both those cases are on Article 6, aren't they?
Yes, but they are sometimes referred to in other contexts. It depends on the wording of the, as your Lordship will know. the central notion, if you're allowed to do something prescribed by law, then the idea is that it has to be done in a way that is in accordance with European rules, the principles of the European Court.
Yeah.
Don't we have to distinguish between two different senses in which the word retrospective is used? One is where legislation is avowedly retrospective. It requires it's a change in the law which is said to
Reaches back in time.
to reach back,
Yeah.
so that what was the position in law at the time has to be treated as something different. But the other sense, which is what we have here, is where a judicial decision declares what the law was at the time of the relevant transaction, which is not avowedly retrospective in the sense of changing the law. It simply tells you what the law always was, and in a sense that can be described as retrospective, as in the debate which sometimes rears its head here as to whether there should be a power for prospective
Yes.
overruling.
Yes.
But those are two very different things,
Beasts.
really.
Yes. My lord, yes. My lord, a number of cases are referred to in the friend skeleton. I'm not proposing to turn them up, but if I may, I will just say this about them. The Solaria case, which is referred to, I'm sorry, first of all, the Douglas and Hello case was actually a case of a clash between two of the competing convention rights. So freedom of expression and right to privacy, and it doesn't help on a case like ours, where the question is, well, how are the banks said to have any rights under one of the articles? Solaria is a case where the situation was one where there wasn't a purported contract which the law of the place of incorporation of one contracting party said that that party lacked power to enter into. So it didn't deal with that issue. The Rosneft case is a criminal case.
Solaria.
Solaria is at bundle 74. It's referred to in paragraph 110. The Merchant International Naftagaz case was a very different sort of case from ours, where there had been a complicated history of judgments in Ukraine and in the UK, and attempts to defeat enforcement of in the UK, and a question about the principle of legal certainty. Very far removed in our submission from our case. Rosneft is a criminal case, and UCOS, also a very different sort of case from ours, about bespoke exceptions to a limitation period, which is, as I say, very different from capacity changes to contract law. So that's all I would want to say about that. And so if I may, I'll turn to the last ground of the banks. On their appeal, which is the limitation ground. I'm conscious your lordship mentioned that we would have a short
Well,
ground.
how much longer are you going to need, or how long are you going to be on ground 5? In real terms, I'm not going to hold you to it.
20 minutes, half an hour.
Well, let's do that and then we'll break.
Thank you, Madam. So, on section 32, what I would like to do is to show you some brief passages in 3 of the cases, put it all together in the context of a case where you are seeking to recover a payment made by mistake, and then look at the judgment of the judge and the criticisms of it. So, if I may, and as briefly as possible, I just want to take you back to FII, which is tab 81. And to begin, paragraph 190, which is page 4867, or +6 electronically. So this is paragraph 190, just at the bottom. Their lordships were quoting from Howard's and Fawcett's. Lord Nichols, and then he's quoting Lord Donaldson. Suspicion, particularly if it's vague and unsupported, will indeed not be enough, but reasonable belief will normally suffice. In other words, the claimant must know enough for it to be reasonable to begin to investigate further, and that is endorsed in this judgment in FII. So your lordships will see 191 and 192. Now, then, if I may, paragraph 210 and 211. So just 210, and I'd like to pick it up. Well, I'll just refer to the first part. So, the application of the approach, the standard reasonable diligence, will depend on the circumstances. And then, for example, in cases where the claimant's made a payment on the basis of a mistaken understanding of the law, which has resulted from ignorance. Now, that's obviously not our case. On the other hand, where the payment was made in reliance on a precedent that was subsequently overruled, or an understanding of the law that was later altered by a judicial decision, the question will be whether the claim was brought within the prescribed period, beginning on the date when it was discoverable by the exercise of reasonable diligence, that the basis of the payment was legally questionable, so as to give rise to a worthwhile claim to restitution. And then it continues on 211. Clearly, where a payment was made in accordance with the law as it was then understood to be, the point in time at which the claimant could, with reasonable diligence, have discovered that the basis of the payment was legally questionable, so as to give rise to a worthwhile claim in restitution, would have to be established by evidence. The focus of that evidence is likely to be upon developments in legal understanding within the relevant category of claimants and their advisors, as explained in one paragraph 178. Thus, in the circumstances of the present case, Lord Walker referred to there being a reasonable prospect that the limitation period could be deferred until the time when a well-advised multinational group based in the UK would have had good grounds for supposing that it had a valid claim to recover ACT levied contrary to EU law. And then he says that point's considered further below. Further, in relation to matters this kind, evidence in relation to this kind may well include expert evidence concerning the status of understanding of the law within the relevant categories of professional advisors during the relevant period. And then, my Lord, paragraph 213. So it's the next page, actually, 4876 in print paper. 4882. So this is the long summary, your lordships will remember. Sub 15. Second sentence. The question under section 32(1) is not whether there was in reality any fraud, concealment or mistake, but whether upon the assumption that there was, it was discovered or could with reasonable diligence have been discovered at such a time as would render the proceedings time-barred. Evidence of a mistake as a verified fact is not the issue. Of course, that was the crucial point. Just emphasise there, so you assume that there was or could with reasonable diligence have been discovered the mistake. I'll just press on, if I may, to the other two and then bring these strands together. Tab 83. Tab 83 at page 4934. 4940, I think, electronically. Paragraph 46 at the bottom. So Geoffrey Voss. At the very bottom, the term worthwhile claim is also not to be construed as a deed. It requires a common sense application. Claim in respect of a concealed event would not be worthwhile, one, if it were pure speculation, but it would be if, as in this case, an authoritative regulator had thought it sufficiently serious, having investigated all the evidence available to lay charges or issue a statement of objections. And then paragraph 51, and I won't read this out, but your lordships, I would invite to read it. Sir Geoffrey Voss gives the burglary example. So you know you've been burgled, but you don't know who's done it.
No, you don't know until they're arrested.
And then you do.
And that's when time starts.
Then you go.
I suppose that assumes that the person arrested has actually done it. If it turns out that the police have arrested the wrong person, then time is not running against the true victim, the true burglar.
Yes. But you assume for the time being it's the right person.
It's very dangerous to assume that everyone arrested by the police is guilty.
And my lord, finally, before I tie this together, TO Computers, tab 78. Infineon, you may know it as.
OT Computers, thank you.
Tab 78.
Yep.
And it's page 4720 in paper, 4726.
Paragraph
47. Judgment of my Lord Justice Males. And I just invite you to read that paragraph, if I may. Now, what I'd like to do now is just attempt to draw those strands together consistently with all the other law about this subject. Overall, the question under Section 32 is, could Venice know or have known of the mistake it made in paying so as to justify a claim with reasonable diligence, acting with reasonable diligence. The standard of reasonable diligence is how a person in the business of Venice would act on the assumption that he desired to know if he'd made a mistake. Thirdly, whereas here the mistake is a payment made under a mistake of law, firstly, you assume all along that Venice had a good claim because of lack of capacity based on speculation and indebtedness. And the question, and secondly, the question is, when could Venice have discovered that the basis on which it paid was legally questionable on those assumed grounds, so as to give rise to a worthwhile claim or good grounds for supposing it had a valid claim to recover those payments. Thirdly, the focus is on developments in legal understanding within the claimants and its advisors in the relevant period as to claims based on speculation and indebtedness. Fourthly, a reasonable belief on the part of a person in the position of Venice with advice that there was a worthwhile claim or good grounds for a claim is enough. In considering that, you apply common sense and don't include pure speculation. And fifthly, and lastly, that there may, and indeed I will submit there are in this case, two stages to what reasonable diligence requires. Firstly, was there a trigger putting Venice on notice? And secondly, what would a reasonably diligent investigation have revealed once triggered? And then if I may just ask you then to, with that, to look at the what the judge said at paragraph 430 in the judgment. So, he gives there in those 6 paragraphs his reasons for coming to the decision that he did. The first two, the first refers to the forum, and the second two Italian law had to be challenged as a matter of fact. The third two, the likely position in English proceedings in light of Prato, and the fourth, Cattolica was a fundamental change. And then the conclusion in the fifth, exercising reasonable diligence, Venice could not have discovered it had a worthwhile claim. Now, the first submission we'd make about this is that we submit that the judge made no error in having regard to the fact that a claim by Venice would have had to have been brought in the UK. There's nothing in our submission in FII or any other case that you can refer to say that you that the party that the relevant party for Section 32 has to exclude from consideration where any claim would have to be brought. It would make no sense for that to happen. Our second submission is that the judge made no error in referring to the likely position in English proceedings in sub 3. In our submission, the judge was not saying that for Section 32, any claim had to be likely to succeed before it could be the subject of Section the application of Section 32. He was not saying that. What he was saying is exactly as appears, that the likely position in England in respect of the claims which was the subject of Prato was as set out, as he summarised there, but he's not addressing the question of, well, what did Venice know, how likely was it that it had a worthwhile claim? That's not the subject of what he's addressing, but it's a completely different thing from what the likely position in English proceedings was. The third submission is that in our submission, the Prato case is not conclusive against me on the question of limitation. The Prato case is referred to by the judge at paragraph 160. I just ask you to look at that in his judgment.
Sorry, where's he?
160, my lord. And 160 little Roman 1, your lordships will see that at the trial before Mr Justice Walker, Article 119 was a provision of a high order. What he held was that Article 119 was a provision of a high order of generality, and the concept of indebtedness was exclusively defined by the list in Article 3 of that law, did not include derivatives, and did not extend to the transactions in issue. In sub 6 on the next page, there was no general prohibition on local authorities entering into speculative transactions under Italian law. And then dropping down, if I may, 161, Court of Appeal. In the second half of that quotation, your lordships will see neither expert supported its essential reasoning. This is the Court of Bologna, which is extremely vague, difficult to follow, and devoid of any analysis of paragraph 17 of the 2000 amendment. Moreover, the amendment to include premiums on derivatives is striking. If swaps were a form of indebtedness already covered, it's impossible to see why the amendment was a rational one to make. So we see there the subject matter of the finding in Prato and its fate on appeal. And that's behind sub 3 of the judgment at 430. And we submit about this, firstly, that the claim as judged by Mr Justice Walker and by the Court of Appeal in that case was a bad claim. And that didn't make, in our submission, a claim by Venice a worthwhile claim, because a bad claim had been made, which had failed at both levels. It obviously was a trigger in the sense that, seeing it, anybody in our position would investigate and ask about it. And so looking at the approach that we've seen, and I tried to summarise in the cases, the question is, well, what should the claimant, with its advisors, in the position of a body like Venice, have considered? Can you say, well, it had grounds for having a reasonable belief that was a worthwhile claim for speculation or indebtedness because of what had happened here? Now, as to that, firstly, we say, as to indebtedness, Prato had decided that the definition in the law I referred you to was exhaustive and didn't include swaps. And if the claimant and its advisors had investigated, that's what they'd have found was said in Prato. They would have seen that's what was said by Professor Torquia in that case, because she was the expert in Prato, as well as in our case. And that would have been where you'd have got to on that issue. As to speculation, in Prato that was obviously not accepted, and we know from what the judge held in this case that he considered that Cattolica represented a very significant discontinuity in the understanding, and so he had, in his judgment, considered the position pre-Cattolica and post-Cattolica. What's more, the judge in Busto had done exactly the same thing. She'd considered the position pre-Cattolica and post-Cattolica. And they both said that absent Cattolica, there would have been no claim for lack of capacity. And they both said that, in principle, after Cattolica, there was a claim based on speculation. So just stepping back a little on this area, in our submission, it's not enough for the bank simply to say, well, there's Prato, it was pleaded, and that's enough. You do have to ask yourself, well, assuming there was a speculation or an indebtedness defence, what should Venice, with its advisors, have considered about whether it had a reasonable belief in there being a worthwhile claim? And in my submission, Prato doesn't, the existence of Prato doesn't support the argument that it should have had a reasonable belief that it had a worthwhile claim, or a good claim, as it put. My lords, the letter referred to by my learned friend was a trigger. Your lordships will remember that it asked, well, how are you considering claims relating to speculation? But it provided itself no grounds for making out such a claim, that is, which would sustain a reasonable belief that there was a claim. It asked the question. And in my submission, it goes no further than that. It doesn't enable one to say, oh well, there was enough there for Venice to have had a reasonable belief that it had a worthwhile, a good claim.
Does that letter come effectively immediately after the collapse in interest rates?
It's dated, I was proposing to get, to come back to the detail behind it, which we are still investigating. But there is a date, a metadate on a document, which is early 2009. Yeah. early 2009, so after the financial collapse.
And was there any evidence below about what, if anything, was done in response to that letter?
I believe not, but I will again come back to that. I wanted to give you everything in one go, and I haven't got it yet.
Well, I asked that in the context that you just accepted that that was a trigger.
Yes,
So it would be interesting to know what if anything,
obviously-
it triggered.
it obviously is a trigger in my submissions. But on the available evidence, no, it takes us no further.
Thank you.
My lords, is that a convenient moment?
How close to finishing are you?
I've finished that ground. So I then need to, and that will deal with the bank's appeal.
Yes.
So I
I
then
think
need
what's proposed is that Ms Delaney now replies and then you present your,
yes,
so you're running in effect an hour and a quarter faster than
yes.
we thought. So if that's a convenient moment, we'll take, which will do 10 minutes. We'll give you 10 minutes.
May I just ask one question? There was some reference to further information or material being provided just now by my learned friend. Obviously, the appeal's about to close when I reply, so which was just
What further, I didn't pick
Exactly.
that up at all.
It's the letter, my lord. We're trying to ascertain its precise date, but as I said, we.
Oh, the date of the letter?
Yes.
I thought it was agreed it was in 2008.
Well, we have a metadata date, which is not that. It's 2000.
What's the metadata date?
It's. May I come back to this after the 10-minute break?
Yes, I mean, this is the sort of question to which you should know the answer, given that this letter was before the judge at trial. The sort of date of it is of some importance. Anyway, there we are. So we'll say 25 past by that clock, please.
All rise.
There's the one which arose yesterday, which is
Just remind me, where is this? That's what we're looking at, yeah.
Yeah. So that, I think everyone agrees, dated 31st of 2008. And then there's the note next to that. And the question yesterday was what is the context of this note? And what we
I thought the judge was talking about. Is this the one we were talking about?
I think that what you were talking about this one because this is the one which refers to speculation as a triggering event, and that one.
Just gonna come from the toilet.
Oh, sorry. No, I'm kidding.
Yeah. But we know that with this one, Carolina has clarified that the Italian version of the document has a file name, I think, with the 31st of January 2009. So that's why we attribute it to
Oh, yeah, I'm not worried about this one.
1st January 2009. The other one has,
This one.
but that one
And
has a date.
Right. And this one, there was no evidence about. Anything done.
There were some documents, but I'm not sure. Yeah, there wasn't witnesses from last time as well. There was some sort of
These various copies.
Email on the copy stuff as well.
Okay, just do it and then send it to me if you like, because I've got to read this. Yeah. Do you want to put it in a Word document? Can you just put this in a Word document, do everything with it, update it or amend it if you
I've got lots of copies.
The original one.
Yeah.
Thank you.
Well, these the only ones. So what do you know? This one. What was it? And what was the other one? It's the extracts from the reports. Yeah.
Thank you, that's really good.
What the reference was that?
I didn't get, sorry, I'm lost as to why this shows case law legislation. No, it doesn't, this is about possibilities. So this is not a judicial. Sorry.
Can you send these out to me?
Oh, I see, so the 2 points of retrospectivity is. Yeah. And this shows that retrospectivity is not enforcing. And in terms of.
This Sorry.
Yeah.
Sorry, I don't want to bother you, but I'm going to tell you that I'm going to tell you this couple of
Sneaky, yeah.
Do you want to give the references?
Yeah, I'll give you these. I can give you these.
It's
Sorry,
quite
come to me.
difficult
I know,
to
I'm sorry.
manage this, I'm afraid. You might need to ask them to wait to come in so I can read it because it's, yeah, I'm replying in a minute. So this is next. Do you want to just check? Thanks, Matthew. That's not in here. Yeah, the point you're making is. Yeah, thank you. Do you mind placing it on the top?
Alright.
Right.
Please, my Lord, may I just mention two matters arising out of our discussion earlier. First is on the letter. I think I may have been at cross purposes with about which one I was talking about. So the one I think you're asking about is tab 50 in bundle S, which is from the City Council Commission dated 31 October. Is that it? Yes.
Precisely, yes.
Yes.
Yes, tab.
It's not the next page, which is a different one. Yes. So,
Which was a couple of weeks after Lehman Brothers, which is
yes.
Which is the point that Maria was
Yes.
making.
And
There's no doubt about the date of that one, is there?
no, there isn't. It's dated at the top, and it was the subject of cross-examination of Mr. De Rossi one of Venice's witnesses on day 4, page 97 and page 101. And the substance of the evidence was it did cause them to ask some questions, and it wasn't about the matters that have been the subject of the judgment in this case. My lords, the other thing is responding very late to my Lord Justice Males's inquiries about the expert evidence about the way that you assess for speculation or even content purposes whether a swap is hedging or speculative. And we've looked, and the best reference we found is in the evidence of Mr Gentili, who was the bank's expert. And I've got here and can hand up the brief extracts of those bits of the evidence where he deals with this. If I can just tell you, the gist of what you'll see there is that he says that if you have a closeout of an existing swap, then you still compare the underlying with the new swap, which includes the closeout. I've only just given this to Millennium Friend, I've only just received it myself. So Millennium Friend hasn't had any time to remind herself of what Mr Gentili says, but that's the essence of it. And it's paragraph 289 of his further report and paragraph 5.24 of his first report. I understand they're coming electronically to your lordships and they're here in paper.
Well, hang on a moment. You've just given us some references. Are these documents in the bundle already?
No.
Well, my lord, that's what I'm. No, they're not. But I was proposing to hand them up so that they could be put into your lordship's supplemental bundle.
Well, I'm going to hand them up unless there's an objection to your doing so.
Well, my lord, I think the objection is the suggestion I could remind myself when I've never seen them before, and I'm just about to reply on them. I think if my learned friend wants to rely on passages, I don't think it's satisfactory to say the gist of them. He'd better identify the specific passages, and then I can see what the target is.
So I understand what Mr Cox has said. It's in response to my question, which is whether the experts below confronted the question directly.
Indeed it is.
Whether which, well, you've got the point, which I imagine was something which you're probably going to address us on.
Which my answer was no, based on the material in the bundle. I'm going to show it to you, but if this is going to change it, I think Mr Cox better tell you where, so I can just read it.
I fully accept the learned friend's concerns. Very happy for her to come back to this anytime she wishes. That obviously doesn't deal with the problem.
Well, that doesn't really, that's not satisfactory.
I know.
Ms Delaney is about to make reply submissions in relation to her appeal, which, other things being equal, one would expect to the end of it. Especially in a case like this where there's the amount of money at stake is enormous. You've got huge legal teams on both sides. It is deeply unsatisfactory. Even though my lord only asked the question yesterday, it is deeply unsatisfactory that we get this effectively after the end of your submissions, Mr Cox. This is something that should have been worked on when my lord raised the point, and we should have had the documents presented to the court and to Ms Delaney yesterday afternoon before the close of play, so she could deal with it overnight. You better hand in the documents and show us exactly which passages you rely upon and where, so Ms Delaney at least knows.
My lord, yes. There are 3 copies for the court.
They're all in one bundle, are they?
In the one bundle, yes. It's for inclusion in, I'm so sorry, my lord.
If you give me the bundle. Thank you.
My lord will see tab 3 and 4. And
My juniors have copies.
behind that,
And they're supposed to go into your other bundle, are they?
into the other
3 and
bundle.
4 in your other bundle. Seem to be 4 copies, but that's probably an abundance of caution again, Mr. Cox. Right.
My
So
lord,
we take that away. Additional materials bundle. Right.
my lord, firstly, can I just clearly apologise for the lateness of this material?
Yep.
And apologise to my learned friend as well. My lord, the first item, tab 3, is from the first report of Professor Gentili. Your lordship will see paragraph 5.24. There's a reference to the MEF circular, and which set out in A, the objectives pursued by local authorities in relation to swaps, and B, this is the part that's relevant, there must be a correlation between the notional amount of the underlying and that of the derivative, which is aimed at hedging. And then it refers to the communication of 1999 dealing with swaps, and Consob clarified what characteristics a swap should have in order to be considered a form of hedging. And then he effectively quotes Consob, including the high correlation. And then, therefore, the correlation between the notional amount of the underlying indebtedness and the derivative doesn't need to be exact. It's possible indeed, it's indeed possible to enter into a swap to hedge only a portion of the underlying.
Sorry, Mr. Cox, when you go back to the start of 524, A and B seem to be the experts summarising what the MEF circular states,
Yes.
not going further than that. And the following paragraph, 525, comments on it.
Yes. In light of the nature of those circulars, it can't be said that they impose any requirements on entry into swaps by local authorities. They give guidance, which is not legally binding in relation to the existing provisions enacted to regulate such financial activity.
I mean, I may be being very stupid, but at the moment I can't see anything in that material. There's a question my lord asked yesterday.
Well, my lord, it's then followed by the supplemental report, tab 4, 2.8.9.
Well, we've got this is Professor Gentili commenting on your experts report. Have you got your experts report in the bundle?
We have extracts from his report. Whether we have this one or not, I don't know.
I do not agree with their statement of 120.
The renegotiation of derivatives constitutes a deviation and so on. Well, Lord, the effective part, well, to be fair, let's read the whole thing. I'd like to point out I see no reason why any renegotiation...
Well, why don't we just read it to ourselves?
Well, Lord, fine. It's the end of the paragraph that is obviously relevant. I should perhaps have shown you this first and then gone into the other one, because this is where he cross-refers back to the earlier document.
That final sentence appears to refer back to the consul requirements.
Yes, yes, my lady.
That's a reference to the consul.
So that's the material that we wanted to show you in response to your question, my lord. My lord, unless there's anything else.
There's no cross-examination about these.
About that passage in that report,
Yeah, about 289.
my lord, I'll have to answer that. I'll have to get instructions on that. I don't want to just...
I mean, what I read him as saying is if the original derivative is a hedge,
Yeah.
which we have to assume this one was, and or it wasn't speculative because that's where we are, as was accepted yesterday. Then when you're looking at the new thing, the new derivative, you're looking to see whether it continues to pursue the hedging intention of the first one, and the extent to which there's a correlation with the underlying instrument, which does seem to suggest that the terms of the original hedging, or the original derivative, are a relevant part of the analysis. Anyway.
Well, I don't want to make any further submissions.
Yeah.
Thank you, my lord.
Yes, Mr.
My lord, I have short points on each of the grounds. The starting point, as I said on day one of this appeal, is that the judge's conclusion on ground one that the swaps were speculative and accordingly void simply cannot stand. And the banks submit that this court is entitled to and should interfere with the judge's decision. And certain submissions yesterday were made about the standard of review. So I will just answer that topic first. The essence of my submission is that the judge fell into error because in determining whether the bank swaps were speculative, he sought to impose his own test. And he did so by applying his own English law approach to the issue in analysing various Italian cases without, I should say, en passant, critically analysing their inconsistencies. But worse still, he then sought to bolster his conclusions by reference to English law cases, some of which were not even on point and none of which were in fact relevant to the exercise the judge should have been undertaking. And we respectfully agree with the way that my lord, the Chancellor, put it yesterday at day 2, page 85 to 86 of the transcript, that the judge was making his own evaluation on the issue of speculation. And therefore there can be no doubt that he brought his own legal judgment to bear on that question, and the case is at the top end of the Perry spectrum. Yesterday, my Lord Justice Mayles asked my learned friend the point that we have just had debated again, whether the Italian law experts had confronted the critical question on the appeal, namely whether the comparison was only between the risks under the new swap and the underlying swap, and that the pre-existing liabilities under the Bear Stearns swap were irrelevant. And that was at day 2, pages 61 to 62 of the transcript. And I think actually the question should be the new swap and the underlying hedging, putting aside the Bear Stearns swap. I think that was the question. And the short answer is they did not confront that question in the way that I think my Lord Justice Males had in mind, because it was not Venice's case. And if they had done, the judge might have analysed that evidence in detail. We don't see any of that in the judgment. In any case, the function of the Italian law expert evidence on this point was limited because they were simply asked to opine on the tests for speculation under Italian law. And the debate focused on whether Consob imposed the relevant test or whether there was some other broader test. And the experts were not asked to opine on how that test applied to the facts. And in fact, although there have been a number of inconsistencies, with no disrespect to my learned friend in his position, his starting point was to accept yesterday that point, and that was at day 2 of the transcript, page 79, lines 24 to I think the end of the passage. And he said, the experts were asked about what was speculative, but the point was made that this is really a matter for the judge, and I think the judge accepted that. And
that must be right, mustn't it? Because the expert evidence was to be directed to what, as a matter of Italian law, would be the test for what was or was not speculation.
That's right. But
the
what
application of that test as to whether this contract was speculative is for the judge, not for the experts.
That's right. But what they didn't do is confront the question that my Lord Justice Males was asking, was as part of the test, do you ignore existing borrowing? And to the extent there is any...
It would be excuse me. It would be a matter for the experts if Italian law has something to say about that.
Exactly.
But if it doesn't, then
Precisely.
so.
Precisely. And it wasn't, of course, Venice's case that it should be put to one side, and I'll come on to that in a moment.
Yeah.
But let me just, I'm just going to pick through, because there were some inconsistencies, and I think it's helpful to do it quickly. I can move on if the point's dead. But following that passage, after the short adjournment yesterday, my learned friend then sought to explain the absence of evidence on the issue because he said it was common ground between the parties that the assessment had to be carried out without reference to the Bear Stearns swap. And he went so far as to submit that the point emerged for the first time yesterday in my appeal skeleton argument, and that was at day 2, page 84 of the transcript. I'm conscious, my lord, that you said that my Lady Justice Falk did not have the transcript, and we have hard copies if that's needed. But I should say that, like the court, we were extremely surprised by that submission. And can I make 4 points on it, just to put it to bed? First of all, the whole thrust of Venice's case below, which the judge accepted, was that the rolling over of the negative MTM made the bank swap speculative. And that was something that my lord, the Chancellor, observed this morning at day 3, page 4 of the transcript. So the rolling over of the negative MTM was, as Mr Cox put it below, the heart of the matter on speculation, and the judgment records that submission at paragraph 224. And we've seen that it was, in fact, the whole focus of the judge's analysis. So it can't be common ground that it had no relevance. And our point is that, having identified that as the key issue, the judge then failed to have regard to the critical fact that the said swap, the Bear Stearns swap, was valid and binding, such that the negative MTM was not a new risk and there was no new borrowing. So it was not just in play, but right at the heart of the reasoning. Secondly, it follows that the references to the evidence below, which my learned friend gave at pages 82 to 85 of the transcript of yesterday, that's day 2, do not make good his submission that the critical issue, that you should ignore what went before, was squarely addressed by the experts, because that is what he said to the court. I think that may have been rowed back from, but just to be clear about this, At page 61 of the transcript, my Lord Justice Mail said, line 21, you've made the point that you have to compare the position of the swap with the position on the underlying risk, and that seems pretty straightforward if you look, for example, at console. But did the expert squarely confront your corollary, which is that you do not bring into account the position under another closed-out swap and compare the swap buyer's position before and after? The answer from my learned friend was, my lord, I can't give you chapter and verse, but I will give you chapter and verse, and yes is the answer. You then put it to my learned friend that I said the opposite, and the Chancellor then said on page 63, lines 16 to 19, but if you are telling us that Italian law evidence was that you ignore the original position, and the judge accepted that evidence, well, that is probably the end of ground one. And Mr. Cox said, yes, that is my, and it's cut off, but I think that was, yes, it is my submission. And you asked him for chapter and verse, and he said at line 23, you will have it, yes, that is my submission. This is the fundamental difference between us. And so that carried on, and then at page 82 to 85, it was picked up after the short adjournment. At line 6 on page 82, just before the short adjournment, my Lord Justice Males was asking me about the state of the expert evidence. And it's summarised then by my learned friend, saying that the relevant swap was between the comparison and of the underlying debt and the swap. That was his expert evidence, line 18 of the transcript. And he then proceeded to give the references for that and for the submission, saying he would make it good. And he gave you the references of the pleading of the bank, tab 18 of the supplemental bundle, sorry, core bundle, page 430.
Tab 18. This is where we got into a fix as to which paragraph he was referring to.
Exactly, but it was he gave you page 430 as the reference, and the reason there was confusion is that he referred to 430E when there is no E, and I think he had in mind paragraph C.
There was a complete alternative and high degree of correlation.
And this is the bank's pleading. And what you see is, far from it being common ground, it wasn't relevant. If you see the last sentence,
Sorry, what page are we on?
436 of the electronic,
Yeah.
and it's subparagraph C, my lady, and it's the last sentence. It was necessary for Venice to replace the Bear Stearns with the transaction because there would not have been sufficient correlation between the financial characteristics. And then I think you were referred to my expert's report.
Well, that was the point that you made to us in opening. They needed to replace the Bear Stearns swap with something else because the Bear Stearns swap didn't correlate with the amended Rialto bond.
Exactly. And this was our case. But
so it wasn't just the negative MTM per se, it was the fact that it was no longer fit for purpose.
That's right. That's exactly the way to put it, my lord. It was no longer fit for purpose. But the point is that it was submitted to you yesterday that it was common ground that you ignore the Bear Stearns swap. And this reference was given as supporting that. Similarly, references to my expert were given. And if I can just turn those up because they weren't, I think, turned up. It's the supplementary bundle tab 19, volume 1, and it's page 147 of the hard copy and 153 of the electronic.
Sorry, give me that reference again.
147, and it's tab 19 of the supplemental volume 1. So this passage from 2.5 onwards, this is my expert's fourth report, starts with a description of the correlation that's required and the consob determination, and he's not addressing the application of the consob determination here at all. And you see that right through to 149. So that reference doesn't support my learned friend's case. And he then gave you the reference to his expert's report, which is in the same bundle at tab 18. And this is her third report, paragraph 8, page 138 of the hard copy and 144 of the electronic. And again, it doesn't support any suggestion that you ignore the prior swap. What we see here is that she was examining case law on the rolling over of a negative MTM. And at the bottom of the paragraph page, you see when an existing derivative is restructured. And if you drop down to the end of that, in these cases, the renegotiated derivative is less connected with the underlying risk than the original one. And then I emphasize, and may. So that's the high point. And she offers no opinion on when that may be the case. And so, first of all, no suggestion that it was common ground, you ignore it. And secondly, no confrontation of that point. And thirdly, the experts weren't being asked to opine on the application of the law to the facts, and she doesn't even go as high to say as will be. For completeness, there was some suggestion yesterday that Professor Alibrandi gave oral evidence on the critical question identified by my Lord Justice Males, and that was at day 2 of the transcript, page 97, line 8. Lord Justice Males said, what might be helpful to know, I don't know, and it might be a bit late to be asking for it, but you began the afternoon by giving us a reference to Professor Alibrandi, which you said was where she dealt with the point about whether you take account of a previous transaction. We will have to look at that and decide what she is saying, whether it does confront that point, i.e. the point that you ignore it. But it might be helpful to know, was she cross-examined about that and what did she say, or was it simply left unchallenged? And my learned friend said that was in her cross-examination, my lord. Now, we have gone through it, and as I said, we were not there at the trial, so I fully accept that, and we've done it at speed. But my learned friend has not produced the passage, and we can't find it. And the reality is that Professor Alibrandi's evidence squarely put in issue the relevance of the fact that the negative MTM was rolled over.
Well, this is the whole point of about what she says in paragraph 8, subparagraph 3, because she refers there to the Orvieto case, which is one of the cases that we've got. And I think, I'm not sure about the Verona case, but, and it's making the point that in circumstances where the existing swap has become, because whether as what's described as excessive and no longer controllable losses under the existing swap, you renegotiate. And what you renegotiate into is less connected with the original, less connected with the underlying instrument than the original swap. So by definition, that's a comparison exercise in itself.
Indeed, and
comparing the two swaps.
My lord, you made exactly the same point which I was about to say at day 2, page 84 of the transcript, consistently. So, at the moment, we don't really understand the point that's being made, and indeed the passage produced this morning from my expert's report just now seems to support what I'm saying. It, again, doesn't seem to, the 289 doesn't seem to support what my learned friend is saying. My third point of my 4 points, to the extent you need it, I don't think you do, is that my learned friend's submission is also unsustainable in light of the bank's written closing submissions at trial. Now, they're not in, these passages are not in the bundle. We have looked at them simply because this point was taken. I can give you the references, and if your lordship wants copies. The court wants copies, we can provide them. But the relevant paragraphs are paragraph 186, where the bank expressly submitted that absorbing the unwind cost did not mean the transaction was speculative. Paragraph 190 was also relevantly explaining, referring to the Bear Stearns swap, and paragraphs 218 to 221 were absolutely on point, addressing Venice's broader speculation case.
Yeah.
So I was just checking I've got the right reference there. Essentially what was said is the Bear Stearns negative MTM could not be wished away, and rolling it over did not render the transaction speculative. And paragraph 306, we made the point that the last minute decision to challenge the validity of the Bear Stearns swap, which I'll come on to, there was an attempt by my learned friend to do so, we said was designed to try and bolster Venice's speculation case by knocking out the prior hedge. So in all of those passages, we drew an express link between the validity of the Bear Stearns swap and the speculation case. And indeed, for your lordship's reference, in Venice's own written closings, there's a helpful reference on this point, and I'm on the standard of review point here, where Venice suggested that speculation was a question of fact for the judge and not of Italian law. And so that was their stance as to what the judge was doing. Then finally, on the standard of review, my learned friend handed up a table to you yesterday, I have to say, which was presented as demonstrating that the experts gave the judge considerable assistance on the interpretation of the authorities. I'm afraid we just can't see that. The table is almost impossible to follow on that point, but I have 4 points on it. First of all, it appears to have been prepared by running a word search across the trial timetable for any reference to each case. Now, that is not helpful because some of the cases were referred to on other topics, not on speculation. And for example, you can see that from the very first entry, Constitutional Court Decision number 1, it's clear from the references to the paragraphs of the judgment in the third column that this was referred to, the second column, third column if you count the number. This was referred to on the topic of whether Cattolica correctly stated Italian law. So it wasn't referred to on the topic of speculation, and it's not even in the appeal bundle, which rather proves the point. Secondly, on the critical topic of what amounts to speculation, the experts did not engage in a detailed explanation or analysis of what the cases said. I think my Lord Justice Mayles also asked that question. I've shown you the passage from Professor Alabrandi's report. Third, my learned friend has not relied on any passages in the expert evidence where such matters were given detailed consideration, nor has he referred to anything in the judgment which suggests the judge was assisted by expert evidence in that way. And I think my Lord Justice Mayles made the point yesterday that in his cross-referencing where he took his propositions from, I think in paragraph 229, he cross-references to cases but not to expert evidence. And then fourth, it's revealing how few of the decisions were actually addressed in cross-examination if you have a quick flick through the table. So standing back on the standard of review, we are plainly in the top end of the Perry spectrum, and therefore this court is entitled to, and we submit should, substitute its own judgment. But in any case, as you know, we say the errors which I've identified were fundamental errors of approach which would justify intervention in any case. Could I then turn briefly to
We're just saying that the references in closing submissions to how the judge should approach the issue of speculation.
The Venice's at paragraph 186.
Yeah.
Would you, I think we may have copies, I'm telling you, I see we've got copies in court, I can hand them up.
Yeah.
I apologise, they're not hole punched. It was paragraph 186.
So should we put this in the additional materials?
Yes, please, thank you.
Don't use a hole punch. So which paragraph are you looking at?
There's 186 of their closing submission.
Should we just read that to ourselves?
Yes, it's the first sentence, my lord.
Yeah.
Yes, well, 187 is also quite helpful. It's
Yeah,
where
187
the judge
indicates-
gets his approach from.
That's how he gets to where he.
Indeed.
Yeah.
My second point of reply concerns the validity of the Bear Stearns swap. I can take this quite shortly, but I did want to engage on the point that my learned friend said yesterday at day 2, page 48, lines 1 to 9 of the transcript, that there was no basis for assuming that the Bear Stearns swap was a hedge and that the court simply made no finding about this. And the short answer to this, which I think your lordship has, is that my learned friend in fact sought to challenge the validity of the Bear Stearns swap at trial on the basis that it was contrary to Italian law, on the basis of a mistake. And that case was specifically rejected at paragraphs 324 to 330 of the judgment.
So we give those
324, 324 to 330 of the judgment. Now this was not on the question of speculation, it was on the question of a mistake as to authority and other provisions of Italian law.
on the basis that you hadn't got approval from the city council.
Exactly. But the first point is it's all over the pleadings. And secondly, what's clear is that Venice did put the validity of the Bear Stearns swap in issue, and the judge positively held that it was valid and there could be no mistake, and no challenge has been founded to that on this appeal. Now, given that finding was central to Mr Justice Foxton's conclusion on the common mistake argument, we say that the fact the Bear Stearns swap was valid and there was no mistake is now res judicata. What's striking is that Venice never even tried to argue that the Bear Stearns swap was speculative. And that was plainly an argument that they could have taken below and did not, and nor did they try to take the point on appeal. They did try and take, I think, a wider point, as my learned friend alluded to, and was shut out, which again doesn't help him. The key point is, at no point was it part of his case before the judge that the Bear Stearns swap was speculative. And given Mr Justice Foxton considered validity and concluded the Bear Stearns swap was valid, that's the basis on which this appeal needs to proceed. And it would be a collateral attack now for the judge's finding that the Bear Stearns swap was valid if Mr Cox was to invite your lordship to treat it as invalid or open to attack. So we say that the judge should have approached the rest of his judgment on the same basis, but he fell into error by treating the Bear swap as essentially infecting the new swaps and rendering them speculative. And that is clear from his findings that it was the rolling over of the negative MTM that existed at inception that caused the elements of the new swap he was concerned about, namely the floor, to be speculative. And he didn't start from the position which he should have done, which is if the Bear Stearns swap was not speculative, and if Bear Stearns could have restructured it without it becoming speculative, the little option 2 in the relevant paragraph I mentioned in opening, then how was it the case that simply novating to new banks rendered it speculative? And there's no critical analysis of that point in the judge's judgment. But what is clear is that the judge does appear to have treated the Bear Stearns swap as not being speculative, but rather a hedge. And that renders the rest of his conclusions open to serious attack. And the strapline on that, as you know, is if it was not speculative if Bear Stearns had agreed to roll over the MTM, surely it could not have been speculative for the banks to step into Bear Stearns' shoes, which is what they did by novation, and do the same thing. And the novation is particularly important in that context, as I said in opening.
Yeah.
The third area of reply is dealing with the consob determination, which my learned friend addressed yesterday. And again, as my Lord the Chancellor said right at the outset of this appeal, instead of the exercise the judge engaged in of reviewing the Italian cases, bolstering them with English law cases, what the judge should have done was asked whether the highest court in Italy would have concluded that these swaps were hedges or speculative. That was the sole question the judge needed to ask himself. And had he asked the correct question, the answer was in fact clear on the material before him. And with all respect to the very lengthy judgment, it was actually quite a short point. The Supreme Court decision of 2017 made it plain, as my Lord Justice Males observed yesterday at day 2, page 89 of the transcript, and the full reference is day 2, page 89, line 21, to page 90, line 9. My Lord Justice Males said that the correct approach apparent from that judgment was to apply the consob determination in order to answer the question. And the reference to that decision, so if you'll note, is the Supplemental Bundle Volume 2, tab 35, page 396 in hard copy, and 404 in electronic, 402, I beg your pardon, electronic. Now, that was the end of the matter, and actually when you have looked at the extracts of the experts' report, you can also see that that's the way the experts focused. And indeed, the experts agreed that if the consol test was satisfied, then it was likely that the transaction would be hedging. And I gave you the references to that in opening. And so that was the starting point. What was the test? It was to apply the consol test. Had the judge then applied the consol test precisely as both the experts seem to be suggesting and also the Supreme Court materially suggested, the answer was actually very clear. Because on the judge's own findings, he was satisfied as to lim A. So that only left lim B because he regarded...
Well, in relation to lim B, he said, well, there was correlation in respect of certain financial characteristics, but
not in
as
others.
he described, important and financially highly significant terms were arrived at for other reasons.
Exactly. So
2292.
And that, as we discussed on Tuesday, the important financial terms he said didn't correlate were the cap and the floor.
Yeah.
And so what the judge...
Your submission is that the only thing that he could have had in mind was the cap and the floor.
Exactly, because he set out in his judgment in the passage that your lordship has in front of you that all the correlation on all the terms actually identified in that Supreme Court judgment to which I've just referred, the 2017 one.
Yes.
And so it's apparent when you look at what he was concerned about, it was just the cap and the floor not correlating. And the references are 228(1), 229(1), and 2 of his judgment. And that concern, as you know, was misplaced because the cap and the floor will never correlate to the underlying borrowing, precisely as my Lady Justice Falk observed yesterday. And it would matter not whether it was a collar swap, all collar swaps would fail, but as my lady observed yesterday, the same would be true of a plain vanilla fixed rate swap, because the fixed rate will not correlate to the underlying borrowing. And that was at day 2, page 61 of the transcript. And indeed, my learned friend accepted my lady's question at day 2, page 61, line 9 to 20 of the transcript. So it shows that the judge's concern about the cap and the floor were misplaced, because you would never have the consol test applying to swaps if he was right, the judge's approach was right, because no swap could ever correlate. So that was, my lord, the end of the matter, and the appeal with respect was that, or rather is that simple, and the case before the judge was that simple on speculation. And
you say, do you, that to the extent that there was a lack of correlation so far as the cap and the floor were concerned, that was on the judge's findings simply because of needing to take account of the negative MTM on the Bear Stearns swap, and that was not a matter of speculation, but simply reflecting an existing contingent liability.
So I have 3 points, my lord, on it. The first is the point that your lordship's made, which goes to the Bear Stearns point, and that is correct. The second is it's a cap and a swap, a cap and the floor may never correlate, even on the most basic of swaps. That's the second point. And the third point is that in any event, a high degree of correlation is required by consol, not exact, and with the features that the judge had found as correlating, looking at the 2017 decision, then there was sufficient correlation to meet the consol test. So on all 3 points, which stand individually, the judge's judgment was wrong. My lord, so what we say is one could have just stopped there, and the appeal can stop there. There is no support though, and I will just continue so I finish it off, for the extreme case in the Italian decisions that we looked at, an extreme case being that you can't even have a plain vanilla fixed rate swap because of the lack of correlation. And the Council of State decision, which I'll come to, was a very helpful decision on this point, and again, a decision of the highest court in Italy, the administrative court. So that should have been taken into account by the judge. My fourth point on reply concerns the judge's broader exercise of identifying indicia.
Sorry, just before you go on, on this point that I was asking questions about, we were also taken to the Supreme Court decision from 2021, which discusses and appears to suggest that discusses the forward rate curve and appears to suggest that is relevant. Were you going to refer to that?
I can come on to that, my lady, I will. Should I just take the indicia point and then come back to that? So the fourth point is the Italian and English case review, which conducted by the judge, which we say was impermissible. So even if this court is not with me on the question of stopping at the consob test and considers that the judge was right to try and review case law for indicia of speculation, we suggest that the exercise conducted by the judge was impermissible, because the only exercise the judge should have conducted if he was going to do that was to look at the three highest authority cases and to be guided by them. Cattolica itself not setting out a test for speculation, but giving some indications within its own judgment, and the other two authorities. And instead, what the judge did was go through various and often inconsistent decisions of the lower court in Italy, rather than focusing on what the highest courts would do. He didn't, when he looked at those decisions, attempt a critical analysis of those inconsistencies with the higher court decisions. So it's not as if one can say that he was trying to discern what the highest court would do, because even where the lower court's decision, like Orvietta, was inconsistent with the higher court decision, he didn't take that into account, but rather simply relied on the lower court decision.
And I think you would say, certainly from the expert evidence you've taken us to, that in conducting that exercise of looking at those decisions, he wasn't being assisted, at least in any detail, by the experts.
No, and you saw that the high point of Professor Alabrandi's evidence in that passage was May.
Yes.
So
that's it.
That's it.
Actually on the expert evidence.
That's right. But worse than that, I would say, where it's absolutely clear that he did not conduct the right exercise, was then trying to have regard to what an English court would think. And we see the references to Vestia and CPC and the UBS case. And that was absolutely impermissible, but more than that, as I said yesterday, on Tuesday, in fact, some of those decisions were not even on point, particularly the UBS case. And what he should have done was taken the three key decisions that I have mentioned, which were the Cattolica decision, the 2021 decision that your ladyship's just mentioned, and the Council of State decision. And three propositions were clear from those authorities. First of all, it's clear that a transaction is not speculative merely because at inception there is a negative NTM. And we looked at Cattolica and Council of State on that, and I showed you and gave you the passages. But the passage in the Supreme Court decision 2021 is at paragraph 2.61, and that's supplemental bundle 2, tab 40, page 486, which refers to it as a completely lawful profit.
Tab 40.
It's tab 40, page 486 of the hard copy. It's 2.61, my lord. And if it's electronic, it will be 492. And you see the completely lawful profit margin is 7 lines up from the bottom.
Sorry, I'm not getting there.
Can you see, my lord, the paragraph starts 2.61 in the present case.
Yes.
So if you go to the bottom of the paragraph,
Yeah.
and it's roughly 7 lines up.
Existence of a completely
yeah.
lawful profit margin.
And that is referring to a negative MTM. And the case was an attempt to invalidate a swap on the basis that the customer was not informed of a negative MTM before they entered into the swap. You can see that from paragraph 1 of the report. And in answer, while I'm in this case, to my lady's question, at paragraph 2.4.2, page 484 of the hard copy, the Supreme Court says that alignment with the forward curve is evidence of a effective hedging strategy, but it does not say, in answer to the question you posed to me, that the absence of alignment will mean the swap is not a hedge.
2.61 goes to disclosure, doesn't it?
It does.
So if the bank is transparent about what its fee is,
Yes,
then that's all right.
exactly.
If it's not, then it may not be.
And that's what the case concerned. That was the claim that a client had been told.
That's clear from what they said earlier, isn't it?
Exactly.
What is important in the present case is not so much to ascertain the existence of profit margins for the bank provided by the conclusion of the derivative, but the fact that they've been negotiated or discussed.
Exactly, and if you go to 478, paragraph 1 at the last sentence, you'll see they claimed in particular the unlawful recording of an initial negative mark-to-market of which the client was not informed. But there's no suggestion that the mere existence of the negative MTM is the problem. And the forward curve, undoubtedly, if you have an alignment, it will show effective hedging, is what they say. But it doesn't suggest, this case, that the absence of an alignment will mean the swap is not a hedge. And the Supreme Court expressly acknowledges that things can change so that a swap falls out of alignment. And for your Lordship's notes, similar references as to the MTM are in 2.9.1, the last sentence. That's at 491. Does your Lordship have it? Finally, the value attributed through the mark-to-market can be negative. And also 2.9.3 again shows what the case was in fact about. It wasn't in fact suggesting that a negative mark-to-market was making the swap speculative.
Can that be read over to our case where the negative mark-to-market is not simply the bank's fee, but the consequence of the Bear Stearns swap as it has become, or is that pushing this a bit too far?
Well, I think I think the starting point is that the judge held that the mere existence, you'll also remember the paragraph where the judge said itself, the rolling over was itself, the mere existence of the MTM is itself a negative MTM is a problem. And just taking it in stages, what's clear from both Cattolica and this other Supreme Court decision is that the mere existence of a negative MTM is plainly not going to render a swap speculative, according to Italian law. One then poses the question, well, in this case, is it different because it wasn't just about the fee? To which the answer is there's no authority to suggest that. And one might have said, well, it's if it was the fee, could the bank be challenged on that? But the judge actually found that the fee was not a problem.
Isn't it? I mean, in a sense, it is the fee, isn't it? Because it's the price that your clients effectively charged for the novations.
Well, it isn't. It's Venice's cost of continuing with a hedge.
Yeah.
Because Bear Stearns had incurred, if you like, the negative. It was the negative NTM under that swap, and the anything additional that was charged by the bank was the fee. But the judge, in his judgment, which is not challenged, held that the fee was not unreasonable or did not itself render the swap speculative or to be criticised. So he was focusing entirely on the rolling over of the MTM, as we see in all that passage of his judgment. And there are 2 points. One, that the mere existence of an MTM, however it comes about, in my submission, can't be sufficient to render a swap speculative, but still less when that MTM was in a hedge, recognised to be a hedge, that existed in the landscape at the time, and nobody was suggesting that it was if Bear Stearns had rolled over the MTM, it would have been speculative.
Yeah.
So that was the first proposition. The second proposition, which is related, is that it's clear that a transaction is not speculative merely because it involves a restructuring. And that is apparent from the Cattolica case itself, which involved a restructuring of a swap, and the swap was not held to be speculative based on a restructuring. And of course, the judge relied on the Orvieto and Turin cases in support of his concern. Does your lordship want the reference to that?
It's 2-9. Two, 229 and 4.
Thank you, my lord. I've misplaced my copy of the judgment as I'm hunting it down.
Decision of the Court of Orvieto.
So it's little 4, and it's the paragraph itself, with the itself in it. But of course, you've got my submissions, I won't repeat them. Neither of those cases are easy to follow. They're not decisions of the Supreme Court, and they can be distinguished on certain grounds, which I've already addressed.
Just give you the reference again to where Cattolica says that it's not speculation merely because it's restructured.
Well, my lord, it's the passages in Cattolica that I showed you were 4.6 and 4.7, which were the negative MTM and the fee passages.
Yeah.
Cattolica itself involved a restructured swap. And my point is that nowhere in that judgment, when they are considering speculation and striking down the relevant swaps, do they strike it down because it was a restructured swap. So my submission is Cattolica itself was a restructuring, yet the transactions were not held to be speculative. And in both Orvieto and Turin, just to say, although I think it's not the exercise to go through them, in neither case was it found that the transactions were speculative because of the swaps had been restructured. So the ratio of the decision, we would say, is not on point anyway. Then the third proposition that you can take from the 3 highest court decisions before the judge is that it is clear that a transaction is not speculative because the cap and floor do not align. putting it perhaps a little bit more clearly, the fact that the cap and floor do not align does not render the transaction speculative. And that is the Council of State decision, which held that an imbalance between the cap and the floor did not render a swap invalid. Now, my learned friend said in his submissions at day 2, page 75, lines 5 to 12, that the court was concerned only with the effectiveness of the overall transaction in that case, rather than with the question of whether the swap was speculative. But that is not correct. So if you go to supplemental volume 1 at tab 32, it's page 364. If you could please read the last paragraph of that. And it will be 370 for anybody in electronic.
It's 364.
And the point is, when considering the economic convenience test, the Council of State held that the collar swap was not speculative, notwithstanding, of course, on the facts of this case, that there was a negative MTM and therefore a mismatch between the cap and the floor. And insofar as my learned friend tried to derive support from the Milan case, it doesn't assist him because it can't be reconciled with these authorities of the 3 highest courts. And therefore, my lord, we would suggest it wasn't open to the judge to then rely on a case that was inconsistent unless he could critically analyse away the differences, which he didn't and he couldn't. And in any case, that authority provided no real basis for finding that the Supreme Court of Italy would conclude that the transactions in this case were speculative, because in the Milan case there was no suggestion that the disparity in the value of the cap and the floor arose as a result of a pre-existing transaction that was not speculative. So we say it provides no assistance. So my lord, that was everything I had to say on ground 1 in reply. The short point is, you can interfere. The relevant test, it should have been consob. Consob answered the point. And for good measure, the Bear Stearns swap itself not being speculative rather predetermined many of the issues.
Okay. Thank you.
My lord, ground 2, I've got 3 short points to make on ground 2. First of all, my learned friend did not engage with my point about why grounds 1 and 2 stand and fall together. And the short point is the judge's reasoning in paragraph 268 of his judgment was infected by the same errors that he made in relation to ground 1. Moreover, it was the evidence of Venice's own expert, Professor Domincelli, that a hedging swap did not infringe Article 1196. And that the reference, we don't need to turn it up, is supplemental volume 2, tab 55, page 688, and it's line 10 to page 690, line 21. It was his cross-examination. Oh, I'm sorry, I've been corrected. It's tab 65, not 55. The second point is that my learned friend wrongly focused his submissions on the economic effect of the novation fees. And there is no support for that test in the expert evidence. And if we could please go to the joint statement of the experts in the supplementary volume 1 at tab 21. And it's page 166, paragraph 210, and I can read it to save time. The experts agree that an upfront payment in the context of derivative transactions is an amount of money paid by one party to another, i.e. the party accepting the less favourable terms, to rebalance the financial situation of the parties in non-par swaps, i.e. swaps whose value at inception is not equal to 0. So the experts were agreed that an upfront is that amount of money which is paid to rebalance and so on. And you have my submissions that there was no payment by the banks to Venice to rebalance the transactions. The novation fees were paid to Bear Stearns, not Venice, and the negative mark-to-market was rolled over, not balanced out. So the test advanced by a learned friend has no support, and his own expert's test was met on the facts of this case, was not met on the facts of this case, so there was no upfront. And the judge obviously derived some of his decision from misunderstanding Professor Gentili's oral evidence, as I showed the court in opening. Professor Gentili did not depart from the view set out in the joint statement. My learned friend then sought in his submissions to make something of Professor Alabrandi's evidence, but he didn't actually take you to it, so may I show it to you?
Yeah.
It's in the same bundle at tab 18, supplementary volume 1. And it's page 141. And the relevant paragraphs are 20 to 22. And the short point is that her view is premised on it being possible to infer a mandate from Venice for the banks to make the payments on their behalf. So her evidence is the same as Professor Gentili's in oral evidence, essentially, that if there was some form of mandate and Venice had been entitled to direct it in that way, then it would have been, may have been different, but there was no mandate, and this would be inconsistent with the terms of the novation.
She doesn't quite say, does she, that she's proceeding on the basis that there was a mandate. She says that the Italian court would construe the payments.
But the premise of it is that it is to be regarded as a mandate. That there would be a mandate, that that's her. It's not simply on the facts of this case, you'd have to infer a mandate. And that's the problem with it, because there is no mandate. The banks made the payments on their own behalf, and it couldn't be clearer from the terms of the novation confirmations. Not least, your lordship will remember the representations made that nobody was acting on anybody else's behalf. And in cross-examination...
Well, like my lord, I'm not sure about 22.1, because it seems to me that she's really saying there is that given that Venice were party to the novations, that the correct, as it were, the correct construction is that they amounted to a mandate by Venice to the banks as their delegate. So there didn't have to be some separate mandate. That's the point, I think.
That's right, and what I'm submitting is, when you look at the terms of the confirmations, you cannot read them as conferring any mandate on Venice's behalf. They would be directly inconsistent with that. And what I was going to say is, the judge did not rely on this evidence. It wasn't part of his reasoning, precisely because it would be inconsistent, I would submit, with the terms of the novation. And just so your lordship has it, now, again, we've had to turn this up in response to my own friend. Professor Alabrandi was cross-examined on this and admitted that from a, quote, formal perspective, there was no upfront. Now, and it was day 8, page 96 of the transcript, and we'll have to supply that to you. So what we say is applying the expert's test in the joint statement and looking at the terms of the novations and not trying to revisit them in this way, it is quite clear that there was no upfront. And what we see, and this is my third point on ground 2, what we see happening on ground 2 again is in fact the judge departing from the expert evidence and forming his own view, using his own legal judgment, based on his own analysis of the economics of the transaction. And there was no support for that. And my learned friend attempted to introduce that test in his oral submissions, and there was no support for that in the expert evidence. And just to put the point finally to bed, it would be of, I think, grave concern to ISDA, the idea that the novation could be interpreted as a delegated mandate or anything like that, given its terms. So I would urge your lordship to look back at the terms of that, which are very clear, that each party is acting on its own account. My lord, ground 3, again, 3 short points on ground 3. First of all, we agree with my learned friend that Italian law and English law come into play, as my Lord Justice Mayles said, essentially Italian belt, English braces, day 2, page 141, lines 12 to 13. And my learned friend put it, once you sorted out what the foreign law says by way of rules, you then have to decide whether as a matter of English law those rules go to capacity. And that was day 2, page 140. Now, the judge, I think, as my Lord Justice Mayles observed on day 1 of the appeal, didn't in fact approach the 2 stages in a logical order. I won't ask you to turn them up, but you can go back to the judgment where in paragraph 270 the judge appears to be dealing with Italian law. In 271 he refers to his English law criteria and says that Article 1196 conferred the power to borrow. That's his Roman 3. And then in 272 he goes back to Italian law, and then in 273 he goes back to English law. So there appeared to be some form of elision, we would say, in the way he approached it. It doesn't really matter, because the real essence of the problem in the judge's judgment is my second point, which is on the basis of Haggersund, the critical question really is whether the relevant foreign law, in this case Article 1196, conferred the power on local authorities to enter into the swaps. And your lordship already has my point that this was not the expert evidence in this case. And in fact, I think it was the unchallenged expert evidence that the local authorities had general civil capacity to contract. And were it not the case, it's difficult to see how the MES circulars and all the other laws were at all relevant. That you could see how everything fitted together, because you had a series of laws essentially prohibiting certain types of transaction, and then guidance making it plain others were permitted. Now, what my learned friends sought to do, which is important I think to note, is that rather than rely on the expert evidence as to the nature of the Italian rules and the structure of the legislation, he sought to build a case from Cattolica itself. But there's nothing in Cattolica which says that Article 1196 confers the power to enter into hedging derivatives. And if you could look please at Cattolica paragraph 8.1. The words, the prohibition on entering into speculative contracts can be attributed to paragraphs 4 and 6. That's how Cattolica describes it. So there's nothing wider to say. Article 116 provides the ability to enter into certain types of derivative. It's the other way round. It's described as a prohibition on speculative. The third of my 3 points on this ground is that my learned friend didn't engage with the point about the penalty for breach of Article 1196 being specified in Italian law, nor our point about it being possible for Article 1196 to be both a restriction on capacity and a prohibition, as Venice submits to the court. Well, can I then turn briefly to grounds 4 and 5? And
Sorry to go backwards, but if I could just take you back to what you were saying on ground 2.
Yes.
I think Mr Cox showed us yesterday the expert joint report, supplemental bundle, tab 21, page 166, where
Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts.
Do we know whether this is genuine or just a test?
Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts.
Well, it sounds to me as if it is a fire drill.
Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit.
What I suggest
Do
we
not
do
use the lifts.
is we adjourn until 1:30.
Thank you,
On the
Lord.
assumption that we can get back in the building for 1:30.
Attention please,
start again at
attention
1:30.
please. A fire has been
Right.
reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use